that the judiciary of Tanzania has undertaken so far in order not to delay the delivery of criminal justice in Tanzania. As presented by Honorable Othman, the President of the United Republic of Tanzania formed a commission to look at how to improve the criminal justice system in the country. And the commission presented its findings and recommendation to the President in July last year. Some of the issues raised by the commission were on the integrated use of ICT by the core stakeholders involved in the criminal justice system, the untimely issuance of judgments and proceedings, the procedure to record caution statements of accused persons during interrogation by the police, the abuse of nolle prosequi by the prosecution, insufficient legal training in different key areas to judicial officers and other key stakeholders, and the procedure in plea bargaining and sentence reforms, just to mention a few. As a result, the judiciary of Tanzania has taken various steps to implement the recommendation of the Commission. And the judiciary focused mainly on the judiciary of Tanzania vision that is timely and accessible justice for all, and Pillar 2 of the judiciary of Tanzania strategic plan, which intends to enhance access to justice and expeditiousness. So some of the key reforms which we are taking is to spearhead and coordinated and integrated approach in the use of the ICT by the core stakeholders and institutions involved in the criminal justice system. That is the citizen, the police, the prosecution, prisons, just to mention a few. Further, the judiciary started to hear cases remotely in prisons through video conferences and introduced the e-court filing through the electronic case management system, which rolled out effectively in November 2023. And to properly deliver justice, the judiciary has gone completely online and paperless. As a result now, judgment, ruling, orders, decree, and proceedings may be signed electronically and can be accessed on the same day. These have been made possible by the use of electronic case management system, e-library, and Tanzli. So far, decisions which have been uploaded on Tanzli are more than 58,000. This efficient retrieval of information has significantly reduced the time and costs in the criminal justice process. Further, the judiciary has also incorporated artificial intelligence in its transcription and translation system for administration and access to justice, therefore breaking down the language barrier in Tanzania and aims to improve court efficiency. The use of ICT that has been spearheaded by the judiciary has also encouraged individual judges to utilize artificial intelligence-powered tools in case management, legal review, and research, and also to obtain valuable insights to support their legal arguments and decision-making process in the criminal justice process. Example of the tools that are used by judicial officers are ChatGPT, Grammarly, Google Translation, Zoom transcription and translation, Quillbot, Copilot, Canvas, and Gemini. In addition, the judiciary has introduced or amended rules, guidelines, and manual to address key strategic area in the criminal justice system. Like in Uganda, we have the Court Annexed Mediation Guidelines of 2024, which aim to improve the use of alternative dispute resolution. We have also introduced Tanzania Court of Appeal Amendment Rules 2024, which aimed at decreasing workload before the Court of Appeal. We have also made magistrate courts small claims procedure rules, which is adopted from the Gacaca courts in Rwanda, and the rules do not allow for adjournment and a decision to be delivered within 30 days after a last date of hearing. This is more efficient and faster comparing to the normal procedure, which requires a decision to be delivered within 90 days after the date of last hearing. We have also introduced the Judiciary of Tanzania criminal procedure, audio and video recording of interviews with suspect rules, which aims to reduce complaints by suspects being tortured by the police during interrogation when taking the caution statement. Further, the Judiciary of Tanzania, in collaboration with the Institute of Judicial Administration, have introduced e-learning platforms which provide training to judicial officers and various stakeholders at an affordable price to equip them with the necessary skills on critical issues affecting the criminal justice system in Tanzania. For instance, we have a training on sentencing to make sure judicial officers align and have an increased awareness on the sentencing guidelines. Further, we have trainings on plea bargain on areas which lack clarity, especially on the procedure for plea bargaining. We also now have guidelines and rules specifically on plea bargaining. In conclusion, despite the challenges which we are facing in relation to the implementation of criminal justice system, such as being overburdened with heavy caseloads and suffer from insufficient financial and human resources, the Judiciary of Tanzania has received positive feedback from its core stakeholders on the reforms which have been undertaken so far. For instance, very recently, the Commissioner General of Prisons commended on the reforms done by the Judiciary of Tanzania, that the improvements in the judicial process have greatly helped in managing prison congestion. He added that the national prison capacity, which is 29,900 inmates, but currently the prisons are accommodating around 27,000 inmates. He attributed this reduction in number is directly related to judicial reforms in the criminal justice system, including timely hearing and determination of cases. Finally, as our Chief Justice earlier said, many countries are keen to learn from the Judiciary of Tanzania, particularly on our methods for enhancing justice delivery to citizens in the criminal justice process. We have received delegations so far from Malawi, Uganda, and Zimbabwe, to mention a few. This marks the end of my country perspective in relation to Tanzania on the delivery of the criminal justice system. Many thanks for listening. Merci beaucoup. Asante sana.
Thank you, my Lord. Now we're going into the interactive plenary. I'm going to take a seat, and whoever has a question, kindly raise your hand. Any response? We'll do this for 10 minutes and then go for lunch. Anyone can start. Yes, please, on the left. I hope you have some microphones. Anyone else? Please introduce yourself and then make your comment or give your question.
Okay, thank you very much for this opportunity. My name is Olwande Evelyn from Kenya. I think first of all I want to start off by commending the retired Chief Justice Othman for the paper ably presented, and also all the presenters. And specifically what stood out for me, one of the things that stood out for me is the discussion around admission and submission that is being practiced at the ICC. And I was just thinking for the rest of us, maybe we do want to go that way. Because I see how it would enhance efficiency, especially in terms of time management. Because if you're going the admission way, by the time you've taken submissions on what is admissible, what is not admissible, you make an interlocutory ruling, there's probably an interlocutory appeal, so there's a lot of time wasted there, and I was just thinking maybe as judiciaries in this region we may want to look at that. But in terms of maybe my contribution, I wanted to just mention, retired Chief Justice also talked about having a coalition of the willing with the justice players. I just wanted to share maybe the Kenyan experience. We probably have it in other jurisdictions or not, but in Kenya we have the National Council on Administration of Justice. I believe my sister would have mentioned had she been given sufficient time, but I appreciate the time was not on our side. But basically it's a body that brings together all justice players for purposes of coordinating and ensuring that we are able to move together. So we are all able to sit at one table and discuss and see how best we can be able to improve efficiency for all the players so that we are moving as one and ultimately achieve our goals. Lastly, I wanted to ask, I also believe maybe in the interest, because of time, she was not able to cover that. Rwanda was identified for having a performance measurement framework that also factors in as a parameter the rate of overturned decisions. And that is something also, I also serve in the Judicial Service Commission in Kenya. So it is something even as a commission we've been grappling with, whether that is a parameter we really want to introduce. And of course we appreciate the importance of that parameter, but I wanted to ask, how do you handle the need to ensure that judges and judicial officers are able to make decisions without fear of repercussions? I think even the principle of judicial privilege has behind it the backing that we want judicial officers and judges to be able to make decisions without fear that there will be repercussions in the manner I have decided a particular case in good faith. I don't know how maybe the Rwandan experience, how you are able to guard against that. It will be good to share with the rest of us. Thank you.
Thank you so much. Hello, Justice Ruth. Justice Ruth, do you want to answer that right now? Please go ahead and answer the question.
Thank you for the question. Yes, they mentioned about the system, but I admit I'm not able to answer it very well, but my colleague here can assist. Yes, Geraldine. Please, can you assist?
Yes, please.
How the system works.
So the question is, using the parameter of the rate of overturned decisions on appeal a concern for Rwanda, given that it may curtail judicial independence? That's the question.
Thank you. My lords, all I can say is that for Rwanda, it's not an issue. We haven't been threatened. We have not had an issue. There is no judge that has had an issue. And so to us, it is all smooth. Thank you.
Thank you, my Lord, for that. My Lord Justice Chiborian.
My question goes to the presenter. It relates to the problem of abuse of powers of arrest by the police. There's a growing trend where the police, in exercising their powers of arrest, beat up the suspects, sometimes even causing grievous bodily harm, sometimes causing disappearances, sometimes causing even death. What should the judiciary do to alleviate this situation if it cannot be eliminated?
Thank you, my Lord. My Lord Chief Justice.
Yeah, thank you very much. Well, maybe just briefly, just a comment concerning measurement of overturned convictions. Okay, this system is used in a number of countries, not only Rwanda, but I think also in some states in the US. And of course, in terms of measuring judicial performance, always two questions arise, which is qualitative assessment and quantitative assessment. And I think, as was said by our colleague from Kenya, is to ensure that judges are free, and we have to accept that in the dispensation, in judicial decision-making, some errors are inherent. I think there is a book called Bad Judges. Okay, it's a small book called Bad Judges. And it says that making one error is not a big deal, because there is an error in judicial decision-making. Court of Appeal make errors. Supreme Court make errors. And therefore, they are in every Supreme Court, the rule is that you are not bound by your previous decision. Why is it? Because there is an error. There is a review jurisdiction, which in East Africa we borrowed from India. Very rarely, sometimes, is that exercise. So I think it's a question of allowing magistrates, judges, judicial officers to make decisions freely, without interference, according to their level of knowledge of the law. That's why in East Africa we are investing a lot in our judicial colleges. Capacity building, I think, was mentioned here. And I think East Africa, I can say, because I've been in other countries, we are doing much better than West Africa in terms of investing in capacity building of our judiciary and the role played by our Judges Association, Magistrates Association in building capacity. So, yeah, I think this question is really fundamental about abuse of powers of arrest, because from the public eye, whether we like it or not, we are part of law enforcement. When we are not purely law enforcement, we provide oversight over law enforcement, but the public mixes up. So the powers of arrest, when we looked at it in the Criminal Justice Commission here, we said, first of all, the government from now on agreed that they will not be part of any case in which powers of arrest have been abused by public officials. Okay, so it means is an individual who will be responsible. And this arose in a case, there's a case in one of the districts where the district, your district governor arrested. He had a power to arrest. He arrested somebody who was detained by the police by 5 days. And the court, I think rightly, ordered compensation. Okay, about 10 million to the district governor and 80-90 million to the government. So I think it's a good decision here that the government now on, and there's a directive from the Attorney General, that anybody who abuses powers of arrest, places somebody in custody, this person should be sued individually. And here the Tanganyika Law Society is playing a role. They've brought up a number of cases recently about people being arrested by the police on orders by politicians or public servants or ministers and so on in their own. I think for us, maybe an oversight role to be more vigilant. We cannot initiate proceedings, but from that, but just to be conscious of that and then to look in terms of really how we can engage maybe with the bar in bar-bench relationship and so on, because I think the prosecution has a bigger role in that than the judiciary.
Thank you, my Lord Chief Justice. Yes, my Lord Justice Nzoiki.
Yes, my name is Nzioki Makao from Kenya. I commend the entire panel for the discussions that we've had, but my question goes to Honorable Muthoni. When you spoke of the rights of a mentally ill person in conflict with the law, I know you didn't get to dig in deep, but I just wanted to know, do you see a solution either in legislative reforms, or is it in terms of innovative approaches to handling that person who is mentally ill in conflict with the law?
And that will be our last question, unfortunately. We can confer with the facilitators during the break and during the conference. You may answer.
Thank you for the question, Judge. In this one, I would like to give it over to a more experienced colleague. Maybe I can nominate Honorable Gaveru Lewis.
Would the nominee please rise? Is the person here? Just put up your hand so we can give you a microphone. Okay, at the back.
He's there.
Okay, good afternoon. I'm sorry, maybe I did not get the question right, but if the question is about whether the solutions lie in the legal reform or from the jurisprudential point, I think because we have already declared certain sections unconstitutional, it means it will need some legal reform as well, so that the law has to be amended to conform with the jurisprudence that we have developed. I hope I'm right. Was that the question?
Thank you, Honorable, for that answer. Thank you very much. We shall continue this discussion. I would like to thank the Honorable the Chief Justice Othman. I want to thank our honorable facilitators, speakers today, and you, our delegates, for staying here, participating, and just making the room warm during this session. The AC is quite brutal for some of us, but we thank you very much. Enjoy your lunch. Thank you very much.
Yeah, we must apologize that time is not in our favor. We are trying to redeem the time that we lost in the morning. Before we go for lunch, I have some few house meeting announcements to make. First of all, I would like to recognize the presence of Lawrence Mchome, the first vice president of EAMJA when it started. Justice Mchome. Yeah, he's standing on that side.